is on is having some debilitating effect on her. So she has requested an early stand down today at 3 o'clock.
I confirm that, Chair. There was that communicated to me by Ms. Johnson. I communicated it to Ms. Sello, and that's where we are. Thank you.
Thank you, Mr. Lo. Thank you, Mr. Bodlani. We will adjourn at 3 p.m. then.
Thank you, Chair.
Thank you.
Ms. Johnson, then we have an hour to run through some of the issues we had wanted to engage you with on today. I hope you feel better tomorrow.
Thank you, and thank you, Chair.
Thank you. We had just looked at the affidavit and its compliance, or the lack thereof, with Section 27. So now we're at a point where you are in receipt of this affidavit. Can you take the commissioners through every step you took, discussions you had, and with whom, until the point of the 6th of December, when you say you took a decision to refer the matter for a preliminary investigation? Thank you.
Maybe before you do that, let's remember earlier we discussed that after you received the letter from the minister's office, you then spoke to Mr. Perumal.
Correct.
Who then took it from there. Now, when Mr. Perumal, after you speak to him and he takes it from there, does he come back to you to say anything before we get to this point of the Section 27 affidavit?
Commissioner Baloy, what he does come back and say, the gist of which is, he has communicated with Mr. Adams. Mr. Adams indicated that he had reported these 4 dockets that we see in the letter. He informed Mr. Adams that as per IDEC, if you want IDEC to look at a matter, you would have to depose to a Section 27 affidavit. He told him it would be best if he maybe sat with a legal representative, told him where to find the provisions of Section 27, and for him to then, should he still be of a mind, to then depose to an affidavit. That is where that part stopped, and then on the 21st of November, we were in fact then furnished with the Section 27 referral, which is currently in the doc, at least part of the bundle.
Okay, thank you. Then back to Ms. Sello's question then.
Thank you, Commissioner.
Perhaps for my benefit as well, please
Absolutely.
the
question
yeah.
was, we have just very quickly looked at the contents of Section 27 affidavit. And as I understand from the witness's testimony, she has seen it and perhaps has engaged with the affidavit. We are aware that on the 6th of December 2024, she took a decision to initiate a preliminary investigation based on the affidavit. So I would like her to inform the commissioners of the steps she took subsequent to the receipt and consideration of this affidavit up until she took that decision.
Thank you. May I find out if you will be dealing with has reason to suspect at some stage? I'm not pushing you there, not now.
Yes.
Has reason to suspect in 28(1)A at some stage?
Yes.
All right.
I intend to do so.
Thank you. Thank you.
Chair.
Please respond to the question, Ms. Johnson.
Thank you, Chair. I received the Section 27 referral. Once I received the referral, I myself perused the referral. I then decided to give the referral to the team of Advocate Manilal. At the time, I can't recall where he was, but I gave it to the advocate in his team, which is Advocate Ramsamy. The purpose is, as was explained previously, that once you allocate it to a team, commissioners, they would then peruse, see whether there's sufficiency, what next steps must flow. Ms. Ramsamy Advocate Ramsamy then perused the Section 27 and brought a Section 2813 application. And the purpose, sorry.
Can I just interrupt you before you speak to the purpose? You haven't said anything about Mr. Sesoko. Is it?
That is
because
correct.
At that time he's not featured.
It's not featured, and because this was really, some of the 27s are really voluminous, and I like that two-mind approach. This was just a small document where I could quickly apply my mind. And I looked at it and said, let me give it to a team as we would then ordinarily do, because on the face of it, there were offenses that fell within the mandate. I gave it to Advocate Ramsamy, who then perused the Section 27. She realized that there were references made to dockets, and because we didn't have those dockets, the best way, instead of asking Mr. Adams to amplify the 27, as one would ordinarily have done, is to first get these dockets, because he's talking to allegations in these dockets, and he makes reference thereto. So in order to get those, sorry, Counsel.
No, please proceed. Never mind me.
No.
No, continue. I don't intend to interrupt at all. Thank you.
And in doing that, she applied for a Section 2813, which is a preliminary investigation, on the 6th of December. It was a mechanism, Commissioners, for us to then have an authorized investigation in order for us to now determine where these dockets were. Bearing in mind that Mr. Adams has already alluded to the fact that in Cape Town, these dockets were no longer there. He makes allegations. But he then says he opened dockets in Gauteng. So there's no need for us to go to Cape Town. If you opened similar dockets in Gauteng, so there's no need for us to go to Cape Town. If you opened similar dockets in Gauteng, we engage then with detectives in Gauteng. It would have been one of the investigators, it would either have been Mr. Perumal or Mr. Rapeso, who indicated that we need to write a letter to the head of the detectives in Gauteng, who was a Major General Khumalo. It is a formal approach in terms of acquiring those dockets. I did pen a letter under my hand to the Major General, indicating that IDEC was now vested with an investigation and would require the dockets as per the letter, which were the dockets that were referred to in the minister's letter and subsequently by Mr. Adams.
But by this stage, you have now made a decision that IDEC is investigating this matter. By the time you are now asking for dockets.
A preliminary investigation, yes.
Okay.
And a preliminary investigation, if I may, is it might pan out to nothing. That is why it is safer to have done a preliminary investigation, because not knowing what's in the dockets, it could be a futile exercise having a full investigation, using all of the time and resources, and find that actually it's insubstantial to support.
And you did this in terms of Section 2813.
1.3, Chair.
Section
Yes.
2813. All right, thank you.
Thank you, Chair. In the morning, I'd understood that your approach to the head of detectives, I think you said General Khumalo,
Major General
Khumalo, was requesting the dockets was on the 6th of December.
That is correct.
That is the same day a decision was taken to authorize a preliminary
That is
investigation. So it can be on the 6th of December that Advocate Ramsamy made an application, because you are only making a decision on the 6th of September to initiate at 2813 preliminary
The
investigation.
authorization was dated the 6th.
That's your
She would-
authorization.
My authorization. She would have given me the papers prior. I just can't tell you which day prior to the 6th.
What papers would she have given you in this regard?
So it is an application for an authorization, which the ID must consider to approve. So she wouldn't have given it to me on the day to approve on the day.
So at the time she gives you whatever application she does, what is she armed with?
She would have been armed with the Section 27.
She also, at least she got a copy.
She had the 27.
Okay.
Yes, ma'am.
Now, I think it was yesterday or this morning, I came to understand, and maybe I was wrong in my understanding, that prior to the 6th, you and Mr. Sesoko, I thought you said, engaged extensively over this Section 27 affidavit, on the basis of which you then took the decision you did on the 6th of December. Now, in the narrative you just provided, you haven't said anything about your engagements with Mr. Sesoko.
The chair did ask earlier, I said in most of them, I would engage with Mr. Sesoko. This was a very small Section 27. I don't have to give him. It is a practice I do, and usually with the more bulky ones, they have been on the off case or off chance where it's really a small, not small, it's not nice to say small. It might not be substantial, and I am able to go through it myself, apply my mind, and make a decision.
So are you suggesting my understanding all this time has been wrong, that you engaged with Mr. Sesoko on this particular referral? Because that's what I had understood from your testimony.
I didn't engage him on this referral.
It's not, Ms. Law, it's not a misunderstanding. It's what you said throughout, that you did consult with him. If you recall, even yesterday, when I said to you that Colonel Pareaki spoke of a committee, an intake committee, and you said, well, on paper we have it, but we haven't yet implemented it. And so what I do, this is what you said, what I do is I receive it, I consider it, I form a view, I give to Sesoko, and he then took that into account, and he came back to me, and we agreed that this falls within our mandate. That was your testimony yesterday. So it's not a case of misunderstanding. It's you are revising what you said to us yesterday.
Sorry, if I created the wrong I meant when we talked about the intake committee, I was trying to explain that there is no committee, how the Section 27s worked. So if I created that impression or that was it's incorrect, I did not share the Section 27 with Mr. Sesoko.
So too then was Colonel Padiachi wrong in testifying that the briefing was given to the team by Chief Perumal after the case management committee or what had considered the Section 27. That's utterly wrong.
No, that's wrong.
Because you are not a committee, you are one person.
We are not a committee.
Yes.
And sorry, Chair, I did indicate yesterday, there is no committee, and I cannot call Mr. Sesoko and I a committee. I give it to him because he's an investigator, and with me being a prosecutor, it helps that perspective. But there is no committee at the moment that deals with any of the 27s as they come in.
And it might be a speculation on your part, but what could possibly have led Colonel Padiachi to conclude that the investigation referred to the team was following a decision by a committee? What could have?
I think I alluded to yesterday that we're in the process of putting together a draft standard operating procedure manual. It is one of the things that is proposed in the manual, but it is not implemented currently or in effect.
Okay.
I think I did allude to that yesterday.
So, please have regard then to Section 27. Seeing as you are the person who received the Section 27 referral, who considered it, I think now at that point, the question the chair wanted to engage you on, is it correct to say that on your reading of that affidavit, you considered that there were reasonable grounds to proceed with this investigation?
Correct.
That's what you consider. On what basis?
So
That's what you consider. On what basis?
There were reasonable grounds for us to consider the matter based on the allegations made out.
Just the suspicions, and
Just the
nothing
reasonable
more.
suspicions.
And at that juncture, you had nothing but the Section 27.
That is correct.
And then if we go to Section 2813, that section provides, if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation. So by this point, you had, based on just the affidavit, you considered necessary to hear evidence on these suspicions.
That is correct. And the here evidence is not of necessity oral evidence. It's getting the evidence to support, if there is, in fact, to support those reasonable grounds.
But what do you make of the word here, open quote here evidence? What do you make of just that word here?
Is the conducting of the interview with the witnesses,
Okay.
prospective witnesses.
Okay.
And thank you, Chair.
And be a formal process, a recorded process,
It
those
can
interviews.
be a recorded process, yes. More often than not, the 28s are a recorded process, or it is an interview process,
Yes.
and then the statement is taken.
Yeah, but what I'm asking is, in what happened in that interview, there must be a record of it.
There should be a record of it, yes.
On this day, so-and-so met with Mr. Adams at Pretoria from this time to that time. This is what was discussed. Yes, it will culminate in a statement, but there is a recorder.
There should be a
of
recording,
what
yes.
happened. Thank you.
Yes.
And you know this for a fact.
I'm saying that is
Sorry, just a minute. We don't want you going back on what you've just said in response to my colleague, Commissioner Baloyi.
I did say, Chair, there should be a recording. I will confirm that whether or not there was a recording.
When you say there should be, are you referring to this instance, or are you saying there should be a recording generally as a general statement?
In these matters, generally, there is a recording.
So there is a recording.
A recording, yes.
As a matter of course.
As a matter of course.
There is a recording.
Yes.
All right. May I just ask one?
Absolutely, Chair. Thank you.
The Section 2813 hearing of evidence, let me loosely call it that. Surely that the need for that does not undo the requirements of Section 27. Section 27 must have been satisfied. The requirements of 27 must have been satisfied. You cannot, if the affidavit does not meet those requirements, you cannot get to 2813. Is that correct? Do you agree?
That is correct, Chair.
Thank you. So basically, as you would have learnt in your administrative law, those are the jurisdictional facts for, or to trigger anything that gets done under 28.
Correct.
Those are the jurisdictional facts.
Correct.
Thank you.
Just one from me. To hear evidence under subsection 13, do you have to summon the witnesses who are going to hear the evidence in the absence of a summons?
There are oftentimes, Commissioner Khumalo, where you contact the person and they are prepared to come in, or where they do not want to come in, then you do issue the summons in terms of Section 28.
So in this specific case, what happened?
In this specific case, Mr. Adams was contacted, he was prepared to cooperate, and the investigators and a prosecutor then went ahead to interview him.
Ma'am, now it works. Now it works. Ms. Johnson, can we have a record of that section 2813 process that you say happened? Can we just have a complete record of that?
For this,
Yes, that 2813 process.
that would have happened with
Yes.
Adams in January.
Yes, thank you.
Thank you, Commissioners. So, I think earlier, oh, sorry. She's still writing.
Thank you.
You made a note. Okay. Earlier, you indicated that Advocate Ramsamy prepared the Section 2813 application.
Correct.
We don't have a copy of that application. Are you able to provide one?
May I just check with my advocate Marga if they didn't ask for the Section 2813?
No, we
Is it
hadn't
not?
requested it in the subpoena. It's not one of the subpoena documents. So
But we
I'm saying,
request-
now that
request
you
this-
reference it, are you able to provide us with a copy? So then if I understand your testimony, you give an instruction to Advocate Ramsamy and the Section 27 affidavit.
Correct.
And you want Advocate Ramsamy to make an application back to you in terms of Section 2813. Please explain how that works.
I have applied my mind to the Section 27,
Yes.
but I have to give it to a team to also apply their mind and to see whether or not an investigation can be instituted. I took the view at the time that it fell within the mandate of IDEC. But in terms of the prescripts, no investigations can happen if you are unable to comply with an application for an investigation. So we hand it over to the prosecutor, who must look at the 27. She didn't have to apply for a 2813. If she then, after having assessed it, decided it does not fulfill all the requirements. It is consider this matter, and if you agree that it falls within the mandate, we are all lawyers to apply our minds, then please lodge a Section 28 application. She decided to lodge a Section 2813 application.
You said the first part, you give it to the prosecutor and ask her to apply her mind to the Section 27 affidavit, and then express an opinion to you, and then thereafter she lodges an application. Is that correct?
Instead of an opinion, if you agree that it falls within the mandate, you then apply for a Section 28.
Okay. Where is that? Was that your instruction to her? Here is a Section 27 affidavit, consider it. If you agree that it at least discloses a basis for a preliminary investigation, please provide me with a Section 2813 application. Is that more or less how it goes?
A Section 28 application, yes.
Is that how it normally happens?
That is how I recall it happens, yes.
Did its Advocate Ramsamy ever express a view to you on the content and depth of the Section 27?
No, when she brought the Section 28 application, I realized that she agreed with the contents of the Section 27.
And she never expressed a different view that it's deficient, it doesn't comply? No, she didn't?
No.
She also didn't pick up the fact that it doesn't comply with Section 27?
No.
She didn't. You, commissioners, yes, please go ahead.
This application, it's made in terms of what? Because my reading of 13, and it may well be that there's another section to read before I get to 13, but my reading of 13 seems to contemplate that you, for example, upon receipt of that Mr. Adams, Section 27, if you determined on the face of it that it is necessary to hear evidence, you would proceed to instruct that such a process should happen. Where do we see that Ms. Ramsame had to make an application before that inquiry, that hearing of evidence could be held? I wouldn't have a difficulty reading 13 if you said, I looked at this affidavit and determined that we need to hear more, and then I authorized a preparatory investigation. I wouldn't have a difficulty with that because I read 13 to empower you to do that. But you speak of a more involved process where you make the determination that this falls within our mandate, you give it to somebody else for their opinion and execute, and then you say to them, if you think we must do a preparatory investigation, bring that application, and I would like to see where is that contained, that step.